Good afternoon. My name is Diane Miller. I'm an attorney with National Health Freedom Coalition, and I'm here today with my colleague, Stephen O'Connor, and we are going to introduce you to a project we're working on called the Expanded Care Practice Act of 2025. We've been working on this for many years and have been in and out of states on this issue, but this is an effort that we're going to launch a model act for states to use for Expanded Care Practice Act. The reason that we want an Expanded Care Practice Act is we want to protect the right to practice for medical doctors practicing complementary and alternative health care. The holistic, integrated, complementary and alternative health care doctors have been, in many instances, vilified or shut down for their practices, and we are very committed to protecting their right to practice. We're also committed to consumer access to those docs and any other healthcare licensing occupations that need our protection. There are two areas of law, state and federal law, and occupations are generally regulated by the states individually in their own cultures. So we'll be focusing on state law as opposed to the commerce of federal law. States focus on the practice of medicine as an occupation because they want to keep their citizens safe. So they set up different criteria for who gets to heal another person. A lot of laws come into play with occupations, state licensing boards, civil laws, criminal laws, federal product laws, and emergency health powers. And you probably heard a lot about all of the different areas of these for healers in the past 5 years. The practice of medicine state law generally sets up a group that can do particular things and then says, these other people can't do any of these things. They're usually high-risk things that only highly educated occupations can do. But the ways that laws that are crafted doesn't really turn out that way. The elements of setting up a state licensing law are, first, they define that occupation, they set up their education, they set up a board to show authority, they decide what the grounds for disciplinary actions in, they tell people that they're unlicensed, can't practice, and then there are some criminal exemptions for special groups. So I'm going to have Stephen go ahead and talk to you about the grounds for disciplinary actions for some of the doctors and some of the experiences that they've had in case law over the years. Go ahead, Stephen.
And good afternoon, everybody. So yeah, we're going to look at some examples from different case law in different states as far as physicians' obligations. The biggest issue, the biggest overriding factor in terms of negligence is, what's reasonable and then who gets to say what's reasonable. So for example, a case in Missouri from 2000 defined negligence as a violation of a standard of care and found doctors could be disciplined for repeated or gross negligence. And then the Missouri statutes from 91 define negligent as failure to use that degree of skill and learning ordinarily used under the same or similar circumstances by members in good standing of the profession. Once again, really focusing on what's reasonable. And then as far as what the standard of care is, we have to ask, is there more than one? For example, could there be a majority and minority standard of care? Some other case law that, is helpful to understand these concepts. We have a case from Missouri again in 1994 that if there's room for an honest difference of opinion among doctors, then a person won't be disciplined necessarily for being in one group or another. We have a Pennsylvania case from 1992 where they talk about the fact that if a considerable number of recognized and respected professionals in your field would follow a certain course, then you're not going to be found negligent for that. And Texas, we had a case in 1976, basically stating that a doctor who undertakes a form of treatment that a reasonable and prudent member of his or her profession would undertake under the same or similar circumstances is not going to be liable for any harm that a patient may suffer. In Arizona, we had a case in 1967 talking about the fact that even if a small minority of physicians hold a particular view, that can be within the standard of care, where, and to quote the judges, this minority of physicians has not been shown to be other than respectable physicians. Washington, we had a case in 1950, basically where they say that they use the term interloper, that if there is an established standard of care and you're acting outside of it, you're an interloper who must be held accountable. Another one from California in 1994 that we found in the jury instructions that year is that if there's more than one mode of treatment that's considered reasonable for a particular problem, that a physician who uses their best judgment to select one of the approved methods that later turns out to be arguably wrong is not going to get in trouble. So some general issues of admissibility of evidence for complementary and alternative medicine. First off, we have to look at the jurisdiction. Each state has somewhat different laws. And then we have to look at, are we in a court, for example, on negligence, or are we in a disciplinary board or administrative proceeding? So does the evidence need to be from scientific evidence and experts? Are testimonials acceptable? And also, does the evidence, should it relate to the type of treatment or to the type of doctor? Burden of proof is a really huge issue. Oftentimes, the burden of proof is shifted upon to a defendant doctor to prove that they were, in fact, operating within an acceptable school of thought or modality of treatment. And then last on this slide, we had a case of a Dr. Sutton in California where she had offered testimony from alternative experts, and their testimony was dismissed as not being persuasive in that particular case. In terms of legal approaches to protecting the right to practice medicine and other health-related professions, we have two concepts, and then the idea of a hybrid. First is a tort, and a tort is a civil wrong that you can sue over. So suing for damages, according to the standard of care and negligence ideas, versus you could think about contract, and that would be letting the physician and patient negotiate the terms of their relationship with informed consent. And then we can think about a tort contract hybrid where both of these concepts come into play. Now, the problem that we're trying to address with this act is that folks can lose their licenses or be sued when they use alternative and complementary medicine. Now, finding in the California law was that since the National Institute of Medicine has reported it can take up to 17 years for a best practice to work its way down to the average practitioner, they note that it's prudent to give attention to the new developments in the treatment of specific diseases, especially those not yet broadly recognized in that state of California. And solutions are, let's look at some new state laws since 1998 that have attempted to give doctors more or less some level of protection.
So in 1998, one of the first times that I was aware of the expanded practice concept being introduced into a state law for docs to protect them was New York, where they added the word non-conventional. So they said that a doctor could practice conventional or non-conventional, and they wouldn't be shut down. They left the word which effectively treats human disease, pain, injury, deformity. So later, just adding that one sentence, one phrase non-conventional, wasn't really completely effective law because they had a battle of the experts on whether a treatment was effective. So other states tried to do innovative things to protect their holistic doctors. South Dakota protected the chelation therapy docs by saying that you couldn't be shut down solely on the basis that you were practicing chelation. Colorado set up a statute and it said the thing that you were doing would have to have reasonable potential for therapeutic gain. Once again, that brings up a battle of the experts. Oregon defined alternative treatment in part, has an objective basis to believe has a reasonable probability for effectiveness in its intended use. So we always ask, who decides effectiveness and what does that look like in court? California came up with a new law also for complementary and alternative that said that are not generally used, but that provide a reasonable potential for therapeutic gain in the patient's medical conditions. But they had other requirements of in-person diagnosis and other elements to this law that you had to abide by. Minnesota says that you can't discipline solely based on the utilization of complementary and alternative health care now. Mississippi says that if research results are promising and only if the method utilized are reasonably likely to benefit patients without undue risk. So there's always this conversation about how effective is it, what's the risk, what would you have done had you not used the holistic. Kansas went straightforward in the use of lateral for cancer, and they actually just said that doctors can use lateral if they give proper informed consent. North Dakota, they went straightforward with saying that you could not be shut down solely based on prescribing ivermectin for the off-label treatment. Delaware, New Jersey, and South Carolina all went forward saying that doctors can practice acupuncture. So there's straightforward ways that you can deal with this as well. Recently, 2023, Utah passed a really good bill, which we really support because it really protected the professionals that were deviating from medical norms or established practices if the condition described in subsection 5 are met. And then they listed the conditions: does not guarantee any results, fully discloses, provides contact information, and a host of other requirements. But they did directly say deviating from medical norms or established practices, and we were really glad to see that because that really aligns with the expanded practice concept. So in the process of looking at all this, we came up with a freedom solution, looking at all of these different issues: the burden of proof, the effectiveness, the ways that the practitioner under certain circumstances can practice, and we put it into a model act, and Stephen's going to go through that model act with you.
Hello again, folks. So basically, in the big picture, we have three main principles that we think should then allow going outside of a conventional standard of care for services that we're calling expanded services, as opposed to, we're not using the term alternative or complementary in the statute. So first off, the services can't pose a greater risk of direct harm than a conventional alternative would have. Secondly, they have to be provided with reasonable skill and safety, according to the practitioner's knowledge, background, experience, etc. And the third big principle is expanded disclosures, that the patient needs to be clearly informed that the practitioner is operating outside of the standard of care and using an expanded practice. We've got 14 subdivisions, and this PowerPoint will be available if folks want to get a hold of it and study a little more carefully. And I'll touch on briefly all the various subdivisions of the Model Act. First off, in terms of the purpose of the Act, It's to maintain access to all of the healthcare options, including conventional methods and other treatment methods and modalities, which are designed to complement or substitute for conventional treatment methods. The services are defined to be healthcare and healing methods, modalities, treatments, procedures that have not been generally adopted by a profession or that are not generally considered to be within a prevailing standard of care. So some conditions that have to be met for health professionals to be protected are: one, the service has to have a reasonable basis for a potential benefit to the patient. And two, as noted before, it can't pose a greater risk of physical or emotional harm than would a conventional alternative. And last, is provided with reasonable skill and safety according to the practitioner's expertise. And also, they have to comply with the disclosure requirement that we'll touch on. So subdivision 5 is relating to disclosures, and this is, to make sure that patients are fully informed of that the physician or the medical professional is working outside of a standard of care. So we need a disclosure. There needs to be informed consent, including as to the nature and purpose of the expanded practice, the potential benefits, any risks associated with it, and any other information that a client would reasonably need to make a decision. In subdivision 6 of our model, we touch on the idea of complaints against medical professionals, and explicitly state that someone's license shall not be revoked, suspended, or conditioned, or have any other type of negative repercussion or reprimand based on using an expanded healthcare practice if it's in compliance with the Act. Burden of proof. We think this is a very important section to get into law. It puts the burden of proof on the licensing board or regulatory authority of showing that a practitioner was acting outside the scope of the Expanded Practice Act. In terms of evidence, we explicitly include that evidence in a disciplinary proceeding shall include the use of experts with specialized knowledge in the expanded practice. So there has to be at least one or more experts who are not general experts in a medical field, but are expert in the treatment being used and analyzed. In terms of evidence that would be admissible under the Act, it would be expert testimony, patient-client testimony, anecdotal evidence, experiments, research, case studies, and individual practitioners' clinical experiences in treating patients. We have a subdivision that any complaint against a practitioner shall be dismissed for lack of probable cause if there's no probable cause that a patient was directly physically or emotionally harmed, or that the practitioner was working outside the guidelines of this Act. And also, a finding of physical or emotional harm in itself is not grounds for disciplinary action if the requirements of the Act have been met. Also, evidence about the delay of treatment or the use of one treatment over the other cannot be a basis for a finding of probable cause of direct physical or emotional harm, once again, if the practitioner is working in the guidelines of the Act. We have a section on administrative related complaints. It's often the case that doctors who draw the ire of their medical boards may be scrutinized unfairly based on administrative issues. So we include in the Act that a complaint for non-fraudulent administrative office procedures should be attempted to be handled through mediation, counseling, or other proactive corrective action, so that conditions on the right to practice or loss of the right to practice are not the appropriate remedies. And then in terms of civil liability, that would be where a patient, generally a patient suing for malpractice, a claim of negligence or malpractice shall not be found if the patient has been given informed consent to the health practice, has received all the information required by the act, and 3, the practitioner delivered the expanded health practice or service in compliance with the Model Act. Oftentimes there are challenges for medical professionals in terms of knowing who's complaining about them and the details of complaints. So we include a subdivision 13 that practitioners have a right to timely access to any materials and investigation files that are relevant to an action against them. And finally, we include a subdivision that's specific to minors, basically stating that no action can be taken relating to the maltreatment of minors based on a parent's decision to refuse chemotherapy, surgery, or radiation for treatment of cancer, or to obtain an expanded care practice from a licensed healthcare practitioner.
So thank you so much, Stephen. And we are grateful for your attention today. We appreciate any help that you can give to protect the holistic, integrative, complementary alternative care and expanded healthcare practitioners around the country, so that consumers can have access to more innovative options in a safe environment. So change is happening. Health seekers, along with healthcare practitioners, freedom activists, lawyers, and legislators, will shape the future. And we're going to do it without waiting 17 years. And I always say laws and customs must be carefully reviewed, revised, and even repealed if necessary, and new laws created to reflect the development, evolution, and spiritual maturation of a people. So thank you for your attention. And I hope to hear from you if this is something you want help with in your state to pass. Once again, Stephen and I are both from National Health Freedom Coalition, a 501c3 educational organization on health freedom, and National Health Freedom Action, a 501c4 lobbying organization. And we have a lot of passion for this subject and would love to hear back from you. Thank you so much.
Thanks all.